Practitioners are well aware that in 2013, what's on the books now is that we're going to have a $1 million estate exemption and we're going to have a 55% tax rate. Very few practitioners really believe that that's what's going to happen. What will happen, I don't think anybody truly knows. So what a lot of people are believing is we can wait and start to see maybe mid-2012, late 2012, what we can do before we act. And that could prove to be a very, very big mistake. For clients that wait and see what the law will bring, they may end up waiting and paying. Wait and see may become wait and pay. We have a situation now where there's a golden planning opportunity. The gift exemption is $5 million, the highest it's ever been in history. There's also an economic imperative to planning. Interest rates have started to rise, and as interest rates rise, the leverage you get out of note sale transactions, GRATs, and other techniques diminishes. So you want to take advantage of those from an economic perspective. The economy is still very soft, so that you still get some very historically, let's call it, favorable valuations. So the combination of low interest rates, historically low interest rates, good valuations because of the soft economy, and favorable tax rules is an opportunity that should not be foregone. Let me point out 3 or 4 really opportune client scenarios that affect a lot of clients across the board that practitioners should proactively seek out and try to help plan for current gifts. If you have a client that lives in one of the almost 20 states, give or take, that have decoupled from the federal estate tax system, they may face, that client, a very substantial estate tax at the state level, even though they have no federal tax. Because of the $5 million gift exemption, if you have a client in their late 80s, for example, that lives in New York with a $1 million exemption, that client may be able to simply gift away their assets today, no federal gift tax, and gift to, say, a $950,000 level. When they pass away, there's no New York estate tax. They have a $500,000 savings. It can be that simple. Second category of client is, I would use physicians as the key example, but it applies really to a broad array of clients. Anyone that is concerned about asset protection, lawsuits, malpractice, divorce, all of the suits and litigation that's out there, which is a huge swath of practitioners' client base, they should plan aggressively now because this is a golden opportunity to shift wealth. But right now, a large swath of very well-to-do clients, $5 million is more than enough if you already take out their home because it's perhaps owned in a spouse's name, or in many states, tenants by the entirety, it's protected, their retirement plans are protected. A $5 million gift transfer may protect the remainder of their asset base. And you may need to do nothing more than set up a self-settled trust in Alaska, Delaware, South Dakota, or Nevada, are the 4 big states and primary states for this, and simply transfer assets by gift. Practitioners face the most complicated, I would say dangerous, gift tax return season in their life. One of the most important issues is that the zero GST, generation skipping transfer tax exemption that existed in 2010, gave many clients a unique opportunity to do things they've never done before. So for example, if you had a pot trust that was not GST exempt but could make distributions to skip persons in tax GST jargon, say grandchild to simplify, a lot of clients or trustees would have made those distributions to grandchildren to shift assets out because even if it was a GST transfer, there was no GST tax. The problem and challenge for practitioners are on a multiple levels. First of all, they have to ferret out those transfers because clients may not realize what needs to be done in order to report them on the trust income tax returns. So gift season is kind of very complicated because it's not just the gift tax return you have to focus on, but it's the income tax returns. You now had a distribution out of a trust, you got to report that on the 1041, not just the 709. Another big issue for 2010. There was a long period of time with the gift tax roller coaster and no one knowing what was going to happen, that some practitioners were reasonably advising elderly or sick clients, make large taxable gifts now. You'll secure them at a 35% rate because, hey, in 2011, we're going to have a $1 million gift exemption and a 55% rate. At the time those words were spoken, they were fairly reasonable. Nobody anticipated continuation of the 35% rate, and even if you anticipated that, 0 people anticipated the $5 million gift exemption. So a client may have actually made taxable gifts and paid a 35% gift tax rate in 2010, and now in 2011, and they only waited to after January 1, they could have made those gifts free of gift tax. So practitioners need to jump on that immediately. There still may be ways through disclaimers and other techniques to try to either unwind those gifts or redirect them to avoid the gift tax. Perhaps a series and tier of disclaimers may somehow end up winding the gift back under the intestacy law or something, under state law to the donor or to a spouse or something. It needs to be looked at. So if there's any opportunity to unwind these gifts, it needs to be evaluated. One of the most complicated gift tax issues for 2010 is that practitioners, attorney practitioners, set up trusts that were unique to 2010. Those trusts were set up because you could have a trust that's set up that only had skip people, grandchildren, and further descendants as beneficiaries. But unlike your traditional or typical GST-exempt trust, was not designed or intended to go on in perpetuity, but rather merely to provide for one skip of a generation. So in 2011, when practitioners are filing gift tax returns for that particular type of trust set up in 2010, they expressly want to opt out of the GST automatic allocation rules, because you'd be wasting GST exemption allocating it to a trust that's only intended to last for the grandchildren's generation, to continue our example, and for which you don't need to allocate exemption because there was a zero GST tax on the transfer. That same trust, however, if it continued on for great-grandchildren, would now be subject to GST tax on distributions to great-grandchildren. So this affects every aspect of the trust. So to summarize, the gift tax returns for 2010 are unbelievably complicated. There's unique issues that never existed before. Practitioners will, on many events, have to confer back with the attorneys that drafted the trust to ascertain what was intended and how it'll happen. And unlike any other year, the 2010 gift transfers will have lots of tentacles. It'll affect income tax, investment planning, GST allocations, gift tax returns, a whole raft of different avenues.